And yet it looks like the DMCA or French law allows for a prior restraint.
Yeah, because it seems pareciera ser que la it seems that
Start talking Spanish when you get the microphone. Right?
It seems that when you see the exceptions, the cases where you can shut down a website, in the French law is based on and hate speech. So you can assume that that is to preserve the moral order. When you see the Chinese censorship, it's based on preserving the public order. But when you see that it is possible to shut down a website because copyright infringement, what is the exception in
right.
international human rights instrument that allows that?
Okay.
I think that this is a broader question, how the United States respond to the international treaties, but this is part of other conference.
Mi nombre es Hernán Ferrari, soy estudiante de la Facultad. Volviendo al tema de los filtrados por ISP, una pequeña duda nada más. Me gustaría conocer cuál es la opinión de la profesora respecto de los puntos débiles o las desventajas que presentaría el sistema de bloqueo o filtrado bajo petición, upon notice. Sobre todo, más allá de lo que es la parte privada, ¿cuáles son las desventajas o los puntos débiles en lo que concierne a la protección a la libertad de expresarse libremente?
Sí, mi pregunta tiene que ver con un par de comentarios que hizo la profesora, uno a una respuesta y también creo en la presentación, sobre esta línea que parece ser tan clara de que el Estado, digamos que el derecho a la libertad de expresión protegido en la primera enmienda en los Estados Unidos solo es oponible contra el Estado y que no es, parece ser, oponible contra privados. Y me viene a la memoria todo el desarrollo jurisprudencial sobre la aplicación de la Commerce Clause a la situación en la cual hay discriminación entre particulares. Uno de los casos es el caso también de asociaciones que no admiten personas, que fue un ejemplo que diste en tu casa, querés reunir personas que no hablan mal de Obama y eso no estaría alcanzado, ¿sí? Pero sin embargo, creo que es en el caso Dale de la Corte Suprema, que asociaciones que no admiten personas porque no comparten el discurso tampoco estarían alcanzadas. En fin, lo que quiero saber es simplemente si hay algún tipo de discusión en torno a la posibilidad de que el Estado pueda regular relaciones entre privados que afecten libertad de expresión apoyado en esta interpretación de la Commerce Clause. ¿Se entiende?
I think so.
Creo que sí.
If you don't mind, let me address this last one first. You raised the, I think, the Boy Scouts of America versus Dale case. And in that case, the Supreme Court held that this group, the Boy Scouts of America, had a freedom of expression, freedom of association right to discriminate, right? So they could exclude gay men from their association because that was sort of part of their belief system, they assert the First Amendment as a justification for their discrimination, which seems to run counter to the discussion we've been having, right? So the state, if the state was engaging in this sort of restriction on speech, then that would constitute a violation of the First Amendment. But yet there are other components of the First Amendment, including a right of intimate association and a right of expressive association that allows people to gather for their discriminatory and, hateful purposes. Right, so the Ku Klux Klan has a right to march through traditional Jewish community and say hateful things, and that's protected by the Ku Klux Klan's right of freedom of association and right of expressive association, which seems to sort of run counter to what we've been talking about in the context of protecting free speech. So in the United States, free speech is seen as primarily as a negative right. It's a right against, it's a right to prohibit the government from restricting your speech. It's not a right to prohibit private entities from restricting your speech. So, you know, even, you know, a television station, perhaps a cable station, subject to different regulations, other private entities could restrict your speech, and it wouldn't be a First Amendment violation. It might be a violation of, you know, your rights under civil rights laws, right? If they said no gay people are allowed in here, or no gay people are allowed to speak, that might be a violation of civil rights laws. But if the private entity is doing it, then it's not a First Amendment violation under our concept of, you know, the constitutionalism, which is different in different countries. So that's confusing, but maybe I hope that provided some insight. On the question of ISP filtering and blocking upon notice, so I mentioned that ISPs are immune from notice-based liability and are immune from you know, from strict liability. So the question, I guess the question is, why not have a system in which the ISPs lose their immunity if they get notice of the harmful speech? And you know, we do have that in the copyright regime. We treat this differently in the United States if it's copyright infringement versus if it's some other, you know, sort of tort liability. So why not have a notice-based liability only? And the courts have said even notice-based liability is chilling of free speech, because you have the same issues that we were discussing this morning in the copyright notice and takedown context. How does the ISP evaluate whether the complaining party is correct or not that this speech is defamatory? I don't like the way they criticized me on this website, right? Please take it down. I think it's defamatory. And you're going to be liable under this alternate regime because this is notice-based liability. So the ISP might, just to be on the safe side, I'm going to take it down. I'm going to take it down if anybody complains, if anybody alleges that it's defamatory. The courts have said in a case, let's see, the Zeron case in the United States, the courts have said even notice-based liability is in a defamation action is too chilling of freedom of speech. Now, they don't say that in the copyright context. We have a different statute, but in the copyright context, Section 512 of the Digital Millennium Copyright Act, if a copyright owner makes an allegation of infringement, no proof, no conclusive proof, right, that it's infringing, then ISPs, it's a little more complicated than this, but ISPs have a takedown obligation. And the more complicated part, which we were discussing this morning, is that there is a weak right on the part of the end user to say, oh no, I think that's fair use. Please don't take it down. Oh, we won't take it down unless there's a lawsuit that's filed. So there's some opportunity for back and forth there, not very meaningful opportunity.